welcome to Money Matters TV. I'm your host, Doug Hepburn of Hepburn Financial Advisors, a boutique wealth management firm located in Phoenixville, Pennsylvania, providing advanced tax strategies to successful executives, business owners, and families for over 20 years. I'd like to welcome my co-host, Robin Bond of Transition Strategies, a team of tenacious lawyers effectively representing their clients at every stage of the employment relationship. Transition Strategies is not affiliated with Hepburn Financial Advisors or Cetera Advisors, LLC. Hey, Robin, tell us something good in your world.
Oh, it's so nice to be with you again, Doug. I'm looking forward to this topic because you know I love the world of work and everything about it. My life is good. I just was very happy to be at the top lawyers of the mainline reception about a week ago, where I think for about the 15th year, I'm being honored as one of the top employment lawyers in Philadelphia. So it was a great little get together.
Fantastic. Somehow I'm not surprised at that for 15 years in a row.
Thank you.
Great. That's great.
Yeah, well, you take enough knocks and then you learn a few things along the way, right?
Exactly. Well, I know I've had a number of clients that you've worked with and done a very good job with. So very happy with that. So I'm glad to hear that you got the recognition you deserve. That's good.
Thank you, Doug. Thank you.
That's good. So anything new in the world of labor law for you?
Well, what we're going to be talking about today is certainly new, about, the status of non-competes.
Right.
People are worrying about the economy and job offers and stuff. I have to tell you, I've had a real run on people calling me to help them negotiate new job offers lately. So that has been, I think, a very good sign that there are, good offers coming in the employment world. And on the other side, people going out, I was very happy about a week ago to help a woman who was unexpectedly let go, just going a different direction and taking her package, from 12 weeks to 26 weeks. So that helps
fantastic.
a lot. So yeah, it's good to, take a shot out there. If you have a deal on the table, whether you're coming or going, take a shot at trying to improve that deal.
I couldn't agree with you more. It never hurts to ask. If you don't ask,
and then they'll have more
get the
assets to put under management, right? And more money to take care of their families. It's true.
Exactly. And manage that transition a lot smoother.
Absolutely. That's the scariest thing. People are just scared of the uncertainty in the future. And, sometimes you're older and you think no one will want to hire you. But it's just having that cushion of safety and security that makes a lot of difference. And I think people even interview better when they have the confidence to know that they're not desperate. Never want to come across desperate.
No. And that's why it's important to have somebody like you in their corner fighting for them to make sure that they get the best offer possible. So
well, good. As we say, Doug, you don't have any friends at work, like you have colleagues and acquaintances, and HR certainly is not your friend. So if you have a complaint, before you go to HR, go to your lawyer, your employment lawyer, your external employment lawyer, and get a consult and advisement before you go on record with human resources. It's really important.
Yeah, boy, I have to share that with my daughter.
I think I'll say this on every show just to make sure people hear it and remember it.
Yeah, well, that's good advice for everyone in the working world. As I mentioned, I've referred clients to you, and in my end of the labor market, everybody experiences life transitions. Whether it's in employment, divorce, loss of a loved one. And it's never easy, but it does help to have, a skilled professional in your corner to help you weather those storms. And, as part of my continuing education, I was reading that about the wage gap between men and women, that oft quoted factoid that, women earn 83% of what men do in comparable jobs. And but when I drilled down a little bit on that report, I was surprised to see that when it was broken down by demographics, for Asian women, that drops to 67%. Black women, that drops to 65. But what was really striking was that for Hispanic women, that drops to 58%. And for me, this factoid kind of underscores the importance of, one, having single women and spouses involved in the financial planning process early on, particularly since women generally have a longer lifespan than men, so they need their money to last longer. They often take on the role of caregivers for children early in their careers, which has a tendency to hurt their earnings potential later on, but also they end up taking care of parents later in life.
Yeah.
And so, there's some pretty important roles and responsibilities that come with being a woman. And, if there is that wage gap, as the statistics have indicated, that could create issues down the road. So it's important to be able to work with a financial advisor early on. That brings us to our viewer question from Nancy Thomas of Philadelphia, who asks, under the Equal Pay Act, what are some examples of what's covered?
Oh, thank you for asking, Nancy. That's a nice, easy question to answer because it applies to all forms of compensation. The Equal Pay Act of 1963 applies to everything: salary, wages, benefits, stock options, profit sharing plans, vacation pay, holiday pay, vehicle allowances, expense reimbursements, any kind of compensation that you can think of. The Equal Pay Act prohibits employers from paying different wages or different forms of compensation to men and women who work under the similar conditions and whose jobs require the same level of skill, effort, and ability. Now, as you can imagine, that's where the lawsuits come in, where an employer says, well, I'm paying them indifferently because they have a different level of skill or different level of effort. They have seniority. Seniority is an acceptable reason to pay people differently, or some difference that they can justify that is not based on gender. So that is the thing that we look at, when we're talking about, do I have a claim? Like every other claim in the law, you only have so much time to act. You have 2 years to bring to the attention of the Equal Employment Opportunity Commission, which is a federal agency, or the State Human Relations Commission, your concerns about an Equal Pay Act violation. Now, you have 3 years if you can prove that the employer intentionally violated the law, but that's, a little bit higher. We encourage people, not to sit around and wait, but rather to go promptly for a consultation to see if, in fact, you have an Equal Pay Act claim or some other Title VII basis for gender discrimination. So thank you, Nancy. Thank you. I hope that was helpful.
Yeah, thanks for sending that in, Nancy. If there's something you'd like to ask, here's how to send your questions to Money Matters TV.
You can have your questions answered on Money Matters. Please go to our website, money-matterstv.com. On our homepage, click on the banner on the right that says, Send us your questions. While you're on our website, you can find information about our host and guests, as well as show notes and links about this show and past shows. Money Matters is also available as a podcast on iTunes and Stitcher, so you can listen to Money Matters while you're on the go. That website address, again, is money, MONEY, -matters, MATTERS, TV.com.
So whether you work for somebody else or you have people working for you, the human capital equation is an important component to any enterprise. Each party has its own interests that it needs to protect, and this is particularly true when the company has intellectual property that contributes to its success. One way that companies do this is through non-compete agreements. which recently saw some enforcement changes from the Federal Trade Commission. To help us sort through these developments, our guest today is Ken Milner, Special Counsel of Warren McGraw Knowles, an attorney with significant experience in business law. Welcome to Money Matters TV, Ken.
Thank you so much for having me.
So help us understand, what are non-compete or non-competition agreements?
Well, as Robin could probably tell you, non-compete agreements or non-competition agreements are agreements by which an employee agrees, or an independent contractor agrees, to work or not work for another company which does the same type of thing as the employer does. If you work for a company that makes hamburgers and you have a non-compete agreement, you have promised not to make hamburgers for another company once you leave the company that you're at.
But that's not like, McDonald's saying you can't go to Burger King, right?
Actually, there have been agreements that have been tried in that regard. There's something in franchising called poaching, where one franchisee, even from the same chain, will try and get another employee from another company to come work for it. So if I have a McDonald's somewhere in Montgomery County, and I'm not doing that well, but there's a McDonald's down the street from me that's doing beautifully, and I find out that it's because they have a great manager, I may want to try and get that manager. And so what will happen is that many franchisors will require franchisees to agree to a non-poaching agreement saying, no, you can't hire that manager that you want to hire, Ken. You have to go find somebody else.
Yeah. These kind of agreements truly are an antitrust restraint on trade. And then the court of equity has to determine whether or not there is a legitimate business interest that is sufficient, that needs to be protected by enforcing these covenants, especially when you get into the lower wage area workers. So Ken, can you talk about how enforceable non-competes are in Pennsylvania? Like, under what circumstances?
Oh, sure. As you said, the first factor that has to be considered is there a good business reason for the non-compete? But even if there is a good business reason, there are certain restrictions on non-compete agreements. For example, they have to be reasonable in terms of scope. What is it that the employee cannot do for somebody else? If I'm the treasurer or I'm the controller for one company, does that mean I can't be the sales director for a different company? And generally, that's not the case. It means the type of work you're doing may be one way to restrict the non-compete. Another type of restriction is time. Usually, these things have to be reasonable in terms of time. To have something saying you can't compete with us for 10 years or for 6 years is generally going to be looked at as too long. A year, 2 years, and in Pennsylvania also 3 years sometimes can be correct. Again, as Robin said, if you have a good enough reason for it. The third, another type of restriction is a restriction on the geographic scope of the restriction. If I work for a company based in Philadelphia, am I going to not be able to work for a company that's doing similar things in Los Angeles? These days, that has been a big deal because right now, with so many people working remotely and with people, being able to do and ply their trades worldwide, and for companies being all over with internet and everything else, it's hard to decide whether the geographic scope is something that's going to be reasonable. And as Robin alluded to, you will have a lot of case by case basis. So speaking with someone like Robin, someone who has an understanding and a background in employment law, can certainly help you.
Right.
So
And
it
attaching
raises-
excuse me, just one thing, Doug, going after the scope is the number one way you can, you really attack these things. Because if I've only sold in the mid-Atlantic region, then how am I competitive out on the West Coast? Right. Just like you said. Sorry,
Well,
didn't mean to jump in there, but the scope is the big way that you can attack these.
Yeah. Geographic scope is, as I said, it is a big factor to consider. But we have to keep in mind that we live in Pennsylvania. At least I live in Pennsylvania, and most of my clients are, even though I do a lot of franchise work, a lot of my clients, both employers, employees, business people, are based in Pennsylvania. And Pennsylvania is what they call a laissez-faire state.
Right.
Pennsylvania generally says parties can contract however they want to contract. And we're not going to play big brother and look behind the contract unless there's a good reason. The funny thing happened, of course, and one of the reasons that I presume that I'm on is because there almost was a huge sea change here in the United States, which would have affected Pennsylvania and a lot of other states. For example, California right now will not enforce any type of non-compete. California, several years ago, many years ago, said it's more important that our employees have jobs.
Yes. And pay taxes.
And pay, right. That's the most important thing. We want.
There's your public policy reason, right?
Exactly. Georgia followed, pretty much behind that. And they're about, I would say about 30% of the states right now have that some type of ban on non-compete agreements. Pennsylvania is not one of them, except for one that's coming up in 2025.
So it sounds to me like, it's obviously a state by state situation where it's up to the state to determine whether or not they're going to enforce non-compete agreements. And Pennsylvania, I think you indicated is enforcing them or is not. I know you said California is not, but
right. Pennsylvania, as I said, is a laissez-faire state.
Right.
If the companies contract a certain way, then that's what they're going to first look at. However, there's always a certain baseline. The first baseline, as Robin mentioned initially, was that there has to be a business reason for it.
Sure.
But to what extent do you look behind? Pennsylvania has always been one that has said, hey, if people agree, they agree. And that's fine. However, what happened was that earlier this year, in April of 2024, the Federal Trade Commission came in and was going to have a blanket rule that was going to cover every state, saying that there would no longer be non-competes that are enforced. And that was a big change, because so many states said, no, it should be case by case or this or that. But the Federal Trade Commission said, no more non-competes. There are going to be some exceptions, but that's the way it's going to be. At the beginning of September, just about a month ago, I believe it was September 4th or 5th, a case came down in Texas where a judge simply said, we're going to enjoin the enforcement of the FTC rule. Right. And we are not going to allow this rule to take place. So for right now, there is no blanket national ban against non-competes.
That's right. And, I think it's a case-by-case basis that you have to follow, from state to state. And the other thing is that you were mentioning is very fact specific.
Yes.
You always attack your facts. And these are courts of equity. So in equity, the court tries to see, is everybody operating with clean hands? Are we operating with an essential fairness? One of the things we employment lawyers try to do is say, okay, if you want my client, your former employee, not to work for the next year, well, then pay him severance for that year. Right? Doesn't that seem
Right.
fair? If you're enjoining it, and especially true if you have somebody who's, 55 years old and has spent 30 some years of his life in one industry doing one kind of job, and now the only place that person is employable with any kind of comparable earnings capacity is doing the same thing that he's done for 30 years. So that's what I'd say when you're looking at equity. The kind of things that employers can do to facilitate and smooth out this transition and still get their non-compete, but at the same time not harm or injure the employee.
There does a lot of times have to be a balancing act. However, not everything gets to the equitable side of the
Yeah.
law. Sometimes they say, and as I said, Pennsylvania has been one of the steadfast. This is a contract. We don't have something in equity. We had people who had, we were going to assume had equal bargaining power when they made this contract. And so we're not going to look behind it. We're not going to look at the reasoning. Maybe this person is getting paid or has been paid a lot of money because the person did agree to it. And what do you say to the employer who's going to sit there and say, wait a second, this person knows every single one of my customers. This person knows every single one of my trade secrets. This person knows everything. So even in the federal proposed law, the federal, the FTC rule that was going to ban non-competes, there were exceptions. There are exceptions for senior management people who have so much information about a company that going to a competing company could destroy the company that the person is leaving. There are other exceptions. There are exceptions for nonprofit companies and charitable organizations. So they were exceptions under the FTC rule. There was also an exception on non-competes when the non-compete is part of the sale of the business. If I'm going to be selling my business to Doug, I'm going to say, Doug, here, you can have the business, you can have all of the information, you can have everything. But Doug's going to want to say, Ken, some people are still going to follow you, and I don't want to lose those customers. And so under the FTC rule, the sale of a business is one of the exceptions, and you can enforce a non-compete agreement in those cases.
So to me, it sounds like you've got kind of two extremes. One where they you have states that want laissez-faire economics and say, hey, this is the contract, we're going to read it as is, and we're not going to make any judgments on it. At the other end, you've got states like California that say, hey, you know what? These things aren't enforceable. We don't care. We just want everybody employed. But the reality is a lot of these situations are facts and circumstances based. And so to be able to try and codify something is very difficult. Now, I know the federal government tried to do this through the FTC. I'm not sure whether the FTC was really the right venue to do that, or should that have been the Department of Labor? But to do a one size fits all on the entire country on something that is so facts and circumstances based, I got to believe that's pretty difficult to achieve. Is that true?
I think that is a significant part of the analysis, and I think if you read the Texas decision, that is something that was certainly considered, that this should be more specific. The FTC said, look, we have put in exceptions that we have found are important. And so we've covered it. And remember, this case is not over. As someone once said, it's not a question of whether the glass is half empty or half filled. Keep in mind that the glass is always refillable. And
there you go.
the Texas, and so this Texas case, of course, is under appeal. This isn't going away, and I think that's what's important. But what I wanted, one of the reasons that we're here talking about it today is that sometimes people don't hear what happens or the whys, and to also keep in mind that that this is the time now to protect against it in case it comes back. If you represent a business, you can still protect your business even if you can't enforce your covenant not to compete. There are other ways to protect your business. Certain things are still going to be allowed under the FTC rule. For example, you still have the protection of the Trade Secrets Act. So you still have that protection. You can still have an agreement with someone who's leaving that says, hey, you can compete, but you cannot contact any clients that you've had contact with during the last 5 years of your employment with us, or something like that. So you have that. You also have confidentiality agreements, which are often signed as part of your employment agreement.
And we lawyers that represent the people, we are constantly saying, look at all these other clauses that give you, the employer, all these protections.
That's right.
This is enough. You don't need to use a non-compete to keep someone from working.
Only if you have them.
I would like everyone to know out here that if you have a non-compete and you think you're totally stuck, don't think that. Go get it evaluated by an employment lawyer and see what you can do. I negotiate waivers of these things all the time.
Sure.
And I'm sure other lawyers out there do too. So don't feel you're totally stuck.
Oh, and there are all kinds of different things that you can work out. You can work out something with the employee or with the company that the employee is going to go with, saying, hey, tell you what, we'll take 10% of whatever you do for the next year, or something like that, and work out.
I don't offer that, Ken.
Some sort of an arrangement.
I don't know about that.
One other thing that people have to keep in mind, and I'm sure Robin tells her people that all the time. One other thing to keep in mind, that an employer right now cannot sit there and say, gee, I better be prepared. So this is what I'm going to do. I'm going to say to my clients right now, oh, I'm allowed to have a non-competition agreement. I'm going to tell employees right now, well, you didn't have it before, but if you want to continue to work here, you have to sign a non-competition agreement. As Robin will tell you, no, that's not the case. Unless there is consideration, and I mean significant consideration, not just $1 or something like that.
Right.
There has to be consideration for an existing employee who has an employer who now wants to, out of nowhere, put in.
Layer that on.
You know what, Ken? That's a great point, and this has been a fantastic discussion on something that I think every employee and business owner should be aware of. Again, thanks, Ken, for being our guest today and providing such great information for our viewers. I also want to thank my co-host, Robin Bond of Transition Strategies, and all the people who work behind the scenes to make Money Matters TV possible. Be sure to tune in to our next show with Eric Parnell of Great Valley Advisors. And most importantly, we want to thank you, our viewers, for tuning into Money Matters TV, where your money matters.